So we're going to call the Thursday, April 14th, 2022 Zoning Board of Appeals meeting to order. And first on the agenda, under old business and new minutes. So we'll take the March 10th minutes up first. March 10th, 2022.
Motion to accept the March 10th meetings.
Is there a second?
I'll second that.
A second. Any discussion? If not, all those in favor?
Aye.
Opposed? That's unanimous. And we have...
Football, no worries.
And we have the March 17th, 2022 minutes.
I'll make a motion to accept the minutes.
Is there a second?
Second.
Any discussion? If not, all those in favor?
Aye.
Opposed? That's unanimous. And then we have some revised minutes from February 10th. Cassie got a couple of notes, I think, from a woman who had attended, and she pointed out just a couple of slight changes, and I think when I went through them, they looked appropriate as well, so.
Do you know what those were?
I didn't have them highlighted, but... February 10th, I fixed her address as stated, and she wanted it to be stated for the record that barn doors would not be attached to the building, and it would have to be contingent upon approval by conservation.
Which is what you guys had
Thank you.
talked about. Any further questions on that? If not, we have a motion.
Motion to accept the amended minutes of February 10th, 2022.
Is there a second?
I'll second that.
Any discussion? If not, all those in favor?
Aye.
Opposed? Unanimous. Next we have, at 7:05, the continued hearing of Rick Montgomery, 75 Dale Street. And it's my understanding that they're looking for a further continuance, Cassie?
Mm-hmm.
And that's because of...
They still have to wait on the wetland specialist
How long do they have? I mean, this has been, I think they've...
So you are continuing the days, everything, yeah?
Yep.
Yeah, so they,
Yeah.
as long as they're agreeing.
It just seems like a long time.
I know, but they are waiting for, you said a wetland specialist?
Yeah.
Okay.
So do we have a motion to continue this to, for our next meeting?
Yep. April 14th. No,
May.
May, yeah.
So, so I was just wondering, do you think they would be ready by the 28th? Because I'll be here on the 28th.
I don't think so, no.
No, okay. And so what is that date? The next, May 14th, you said?
May 12th.
Oh, May 12th. Okay. So I'll talk to Scott, and maybe I'll be here for that.
Okay, good. That would be helpful.
Yeah, okay. Because I know, I did do the opinion to the planning board
Yeah, right.
on this, so.
Yeah.
I did look through the plans a lot. Okay.
So do we have a motion to continue this through May 12th?
Yeah, I make a motion to continue Rick Montgomery's at 75 Dale Street till May 12th meeting.
Seconded.
In a second. Any discussion? If not, all in favor?
Aye.
And you were going to say something about us, someone complained about we're not speaking loud enough or something?
Oh, yeah.
Tell
If you could-
everybody.
If you could speak into your microphones more clearly.
For TV's sake.
Well, somebody
For
is
TV's sake,
complaining
yes.
that they can't hear. Somebody can't. There's somebody on this board, so. I know it's on me.
I'm pretty loud too.
Yeah,
So.
I know it's on me.
Come in.
All right, at 7:10, which we are at now, we have a continued hearing on Abington Investments LLC, 1015 Plymouth Street, comprehensive permit dated 11/19/2019, which is a vote on substantial modification.
Yeah, we'll tag.
Who's first? Don't fight.
The client always goes first.
Mr. LaPointe,
Hi.
are you?
Yep, thank you. Glenn LaPointe, 311 Lincoln Street, Abington. Yeah, we're here for, I guess, hopefully final review and final decision on the project. We went over it last meeting. I think everybody kind of got brought up to speed. And I think Amy had some things that she was going to write up for you guys to look at, the modifications. I think she's done that. Hopefully we can kind of go over whatever remaining questions you guys have and kind of figure things out.
So, so if I may, Mr. Chair, so the only, Dale, this is this one. So the only, as you know, the changes that were made to the site plan were changes that I think are beneficial to the project, and obviously I don't vote on this, but it appeared to me at the last meeting that the board thought that those were beneficial. A lot of them were things that we commented on that we didn't really like the first time, which they've fixed, like the bridge. You know, so I sent you a draft decision, and in that draft decision, if you look under the procedural findings, under number 4, if you go A through I, those are essentially plan changes. So both Mr. LaPointe and Attorney Bailey have confirmed that none of those plan changes require any additional waivers. So we're still under the same waivers that we originally granted to them. And just as an aside, when we're looking at a modification of a comprehensive permit, we can only look at the modification. So we can only look at what they're modifying. And so these plan changes, the only thing they're modifying are, you know, certain changes to the plan that don't require waivers, which is, you know, pretty easy. So that's good for us. And again, I think that you know, some of these, we did work through some of these at the last meeting regarding the bedroom count. And the other thing that was brought up at the last meeting was during the original comprehensive permit, there was a lot of abutter concern with regard to screening and traffic. And for example, on Plymouth Street, when the cars come out, would they be shining lights into the houses across the street? And the applicant had agreed at that point to implement screening that was going to be agreed upon by the applicant, by the abutters and the applicant. And so at the last meeting, the applicant did confirm that none of that is changing. So none of that's changing. None of the screening at the entry on Plymouth Street, there's the houses on either side. None of that screening has changed. So it's really, all the changes were made back in the project where there's not a lot of abutter concern back where the actual project is. It was more the entry to the project. So we clarified that there was not a lot of concern. None of these changes would impact any of that concern. So number 4 on page 2 of my draft lists out all of the plan changes, and then number 5.
Can you just go through those just for people?
Oh,
at
sure,
home, just so
sure.
they-
So they took out the bridge, and there used to be 2 buildings, building A and B, and now it's 1 building. The basement was eliminated, and the fire department has previously testified that they are happy with all of the changes. So even with the basement being eliminated, there were changes that the fire department requested, and then the applicant made those changes on the revised plans. And the fire department's happy. The roof design was modified. There's another building entrance, which was near the senior center, which was actually one of the things that we had talked about during the original hearing. And then there's 2 accessible parking spaces. They've obviously, because they've taken 2 buildings and combined them into 1, there's now just 1 lobby. And then the total bedroom count changed, which we discussed at the last meeting. there used to be 112 one-bedrooms, now there's 72. And then there's, used to be 32 two-bedrooms, and now there's 72 two-bedrooms. So the bedroom count went from 176 to 216. The unit count has stayed the same. So the unit count is 144, which with, I think, 32 or 36 affordable units.
25%.
I think it's,
You know better than ask.
yeah, I know. So that's why I took out my calculator. So 144 divided by...
It says in here 36 of those units will be
36. So
affordable. Yeah.
there's still going to be the 36 affordable units. And then the square footage changed because they've taken out the basement. And then the parking, they originally stated that the parking had not changed, but actually we found out from the plans, it actually changed. They added a space, which the board was looking for extra spaces, so that was actually good. So the condition that we need to discuss tonight is condition number 23, which originally stated that if the project is restricted to persons over 62, then no person under the age of 18 may live in any unit. And it also stated that if the project is restricted to persons over 55, then a person under 18 shall be permitted to reside in an affordable unit. Now, that is a common condition. And I've also done affordable projects with conditions that outright say you cannot have people under the age of 18 living in any unit. Now, because this is a 40B and the applicant has financing, and their financing is through HUD, which means that they are more restricted with regard to what they can allow and what they cannot allow with regard to families. So the Fair Housing Act does not allow you to discriminate against familiar, is that how you say it? Familiar status? It's basically family status.
Yeah, it's FAMILIA.
Yeah. Familiar status, anyway. And so that's where we're at. We now are at a situation where we have an applicant that is going to build a 40B that's going to give us 36 affordable units to our SHI. It is age restricted, there's no question that it's age restricted. However, there's this element where people that are not over 60, not everyone that's going to live there is over 62. So that's what we come down to. And so since the last meeting, I can tell you that I have corresponded with Attorney Bailey numerous times. We've spoken on the phone, we've exchanged emails. He's gone through the FHA, I've gone through the FHA, and we really haven't come up with much. And so he has suggested on page 3, there's a condition which so just so you guys know, I went through our 40B decisions in my firm, and as you know, we represent about 2/3 of the Commonwealth. So we have a really big database of 40B decisions and age-restricted decisions, and the condition number 23, the proposed condition that Attorney Bailey actually came up with, is better than any of the others that I've seen. It's more restrictive than the ones that I've seen at my own firm, which actually it requires, so the applicant is proposing to limit or to condition the age restriction to 62.
Yeah.
So that in and of itself is big, that he's limiting it to 62. And so by
55 is out.
55 is out.
Yeah.
Okay, so it's going to be It's age restricted to persons over 62 of age. So by doing that, we are allowed to require that every single unit has someone over 62 in it. And that person is called the qualified occupant. And that's essentially all we can do. So every unit will have someone over 62 in it. That person will be the lessee, correct?
Right.
So, you know, this is a rental, which means, oh, actually, I'm sorry, I said we got 36 units on our SHI. You're right, we get 144 on our SHI, because this is a rental. So every single lease agreement will require that the lessee is 62 or over. And that's as far as we can pretty much go. So the concern of this board was if you had a lessee that was 62 years old, and then that person, so say that person's daughter moved in with them and that daughter had 3 children. There could be 3 children living in this complex. Now, I think Attorney Bailey has things to say about that, so.
That means every unit,
Every single unit could have people under 18.
not just the, you know.
Affordables, no. No, every unit.
So it's not really,
So the argument, I won't speak for
Yep.
Attorney Bailey,
Yeah,
so.
I mean,
Attorney Bailey?
thank you. Really, I mean, the argument is maybe 3 points. The first is that we chose to do an age-restricted program. And, out of consideration or minimizing the number of people under 18 and impacts on schools. And as a practical matter, I do a fair amount of this work. And even in unrestricted apartments, you usually don't get a lot of school-age children. But once you put an age restriction in, particularly if it's 62, Amy's completely correct. You can end up with people under 18. But just the dynamic of it is that it's unlikely, because everybody has to be, the lessee has to be 62 or over. So it's unlikely in that sense. The other thing, and we went back and forth, and I've actually got a little blurb for you here. Let me hand this to you to hand out. That talks about, a couple of the legal things that we're wrestling with here. The first one is a Massachusetts statute, Chapter 151B, which is titled Unlawful Discrimination because of Race, Color, Religious Creed, National Origin, Ancestry, or Sex, and says it's the unlawful practice for an owner to refuse to rent or lease or sell or otherwise to deny or withhold from any person a rental because such person has a child or children who will occupy the premises with such person. That's the state law. And then I clipped a blurb from, kind of the direct HUD program that we're working with, which is, HUD and Federal Fair Housing, their basic rule is you can't put an age limit on anything. You can't say over this or under that. They have exceptions for elderly housing projects. They have an exception that creates the over 55 program, and they have an exception, and this is the one that we're going forward with, that creates the over 62 program. And it's on the second page, 3.11.1.1, which is restrictions that are allowed by HUD statutory authority. It explains the section 231 program. I'm not going to bore you with all these details, but I highlighted it. Several of these programs authorize properties to restrict occupancy to households in which at least one person is 62 years old, and which may include children under the age of 18. So those are the kind of chapter and verse, I think both practical and legal reasons that while it can happen, the likelihood of there being a large population of children is very minimal. Just a couple of other things. We have to do a tenant selection plan that's required by the state. It explains how you're not going to discriminate, how you're going to comply with all the state rules. one of the things you can put in that tenant selection plan is a maximum number of tenants per unit. I think it's two, I'm not sure what it is. I don't want to be wrong, but it's not a big number. It's probably 4 for a 2-bedroom unit. And you can put in all of the things that people have to do to qualify. I proposed language in there that we provide that tenant selection plan to the board before we submit it to DHCD for approval. So we'll work with you on that. Another thing that we can do is we can request a local preference, which means that people in Abington, the local preference varies. Sometimes it's 50%, 60%, 70%. But in effect, what happens is the affordable units are offered through a lottery, and that lottery is open to Abington residents and people with Abington connections. For example, if your mother, if you were an Abington resident, in your 40s, and your mother was 66, but she lived in Weymouth, she'd be eligible to apply. But we can do, that sort of tenant preference as well, to try and have as many Abington residents take advantage of the affordable units as possible.
And then, if I may,
Yep.
I'm sorry, you also mentioned that the amenities that are offered
yeah,
are not
I mean, that's the other thing.
conducive to children.
Yeah, these projects they're designed for people 62 and over. They're not designed for people with children. There's no yard, not every yard, no place really.
There's no pool, there's no clubhouse,
playground.
so
Yeah.
Well, of course, that's the reason why, is because when he came in front of us with this project, it was for seniors, not for children. And that was one of the big sellers, it's for seniors. No children, no burden on the schools, no burden at all. But now there's going to possibly be a burden. So, I mean,
Well, but
I went through the whole thing from A to B.
there's a real distinction. I mean, we could have come in with a project that had no age restriction whatsoever.
But you didn't. You came in with the senior housing. That's what you came in
We
with.
did. We
You
did.
didn't come in with every unit's going to have children in it, possibly.
Yeah, and,
What?
I wish I had that back.
You
okay?
don't, I mean, but I just, you came before us, all this long, Amy, we were there,
yeah, they was.
and now there's going to be children involved.
There
Where
was-
there wasn't supposed to be any burden on the school system or anything.
But can you get HUD financing if you have that kind of a limitation on a,
No, you can't. And so, so actually, during the original hearing, I did bring up the fact that the state statute doesn't allow us to eliminate any, children under 18. We were told at the time that if they made it 62 and older, they could do that. That has, whether that's right or not, the financing, right now, the financing that the applicant is going through is not going to allow it. They are looking at HUD financing, and HUD financing will not allow us to completely prohibit children under 18. So we are looking at we're looking at 144 units, but you do have some 3 bedrooms. You must have.
No, we don't have
You don't.
any
How do you not have 3 bedrooms? How is not 10% 3 bedrooms?
We got in, we applied before that
Okay.
requirement went into
Okay.
effect.
So we're looking at 1 and 2 bedroom units. So, with the tenant selection plan, we can limit the amount of occupants in the 2, so it's the 2 bedrooms that are going to be concerning.
Can you go in a little bit more on the tenant selection plan and how we could be involved with that and what that actually
Is that
would
legal?
entail?
The tenant selection plan, we can limit the amount of occupants. The one thing that I don't necessarily agree with Mr. Bailey on the local preference. The local preference usually is for residents of the town and employees of the town. I don't know about parents of residents of the town, but in any event, I'm sure that residents of the town and employees of the town are going to, that, just right there, you're going to have enough people that will satisfy local preference.
But-
And local preference is definitely legal.
But how does this tenant selection plan, how, is it binding? Who enforces
So
that?
it's a plan that is accepted, and then there's a monitoring agent. So generally what happens is after there's a decision by the Zoning Board of Appeals on a 40B, that's it. So I kind of call it the front end and then the back end. So the front end ends when we issue the decision, and then the back end is all of the tenant selection plan, the monitoring agreements, the financial check-ins where DHCD makes sure that the applicant is not making more than the 20%. All of those things are done through either the subsidizing agency or DHCD. And those are the people that implement the tenant selection plan and the lottery and the local preference and all that stuff. And so yes, if we required that there would be a tenant selection plan, which is in the condition,
It is in the
the
condition.
draft condition, then there would have to be a tenant selection plan where we can set how many occupants can be in there. I would have to, does the original decision have a condition with regard to local preference? I don't remember if it does, but if not, I can change the modification to add a condition
That's fine.
for local preference. So,
May I ask a question?
sure.
Would it be in this condition or in the tenant selection plan where you could say require the person who is the lessee to be in residence like at least X many months a year? Because you wouldn't want somebody to lease something and then let their daughter and their kids live there, and they're the lessee, but they wouldn't.
Yeah, that's a great point.
That's a good point, yes.
Yeah,
Because I know,
I think that probably works.
we could probably do that in the tenant
and
selection
then
plan.
could you
Yeah.
also add the other restriction of that other persons who stay there have to be related to the lessee or under some kind of guardianship or, legal
Yeah.
guardianship arrangement?
We could probably.
I don't know.
I don't know either, because then we get into the definition of family, and then we're back to
Right,
that the Supreme Court Ohio case, which I don't want to get into.
Yeah, I don't want to
Yeah.
make a mess out of it. Just
Right.
if you're trying to make sure
Agreed.
that people are actually following what you intend
Yeah.
here, or we intend, then make sure that somebody's in residence who's 62 and over.
Right. So your first point is excellent about the person has to be in residence. And I don't think that would be a problem at all. It's the second point that we would have to check on.
Yeah.
I don't want to cause any more.
I think that may come through one of the definitions of qualified occupant.
Yeah, it
Right.
might, you're right.
Yeah.
At least a certain amount of months per year. Certain amount of
I mean,
months.
some people may want to go to Florida for the
Exactly.
winter, and I don't,
Yeah.
that seems okay, but like
Yeah.
having somebody who's, really
Right. Yeah.
a de facto resident.
They sign the lease and then you never see it.
Yeah.
And who's in charge of that?
That would be,
Track of it.
that would be the monitoring agent, which they have to, so if the monitoring, so if we make that a condition, the monitoring agent should follow that condition, but if they do not follow that condition, then the building department can enforce the comprehensive permit that we issue. So we do have enforcement authority under the comprehensive permit. And sadly, I've had to actually go into land court and get comprehensive permits enforced. So I've done it before, so we would have that. So the lessee has to be there for a certain amount of months per year, which we can figure out how many months. And then the second one, we have to figure that one out. The whole family thing.
Just so you don't get anybody
Yeah.
finagling.
Yeah. And that might be a little bit more difficult because
Yeah.
there is a Supreme Court case about the definition of family and
Right.
how we do that. So,
I have a question, I don't know. What happens if the leasee, or the...
Passes.
passes and then there's children under the, age of 18.
They're out. They're out.
But I thought there was the restrictions on forcing people out of, housing if they're under 18 or over 62.
Not in this instance, because in this instance, the lessee has to be over, they have to have a qualified occupant. So the qualified occupant has to be over 62.
As a practical matter, how long would they have to be out of there?
I don't do landlord tenant, but
I'm sure they get a reasonable amount of time.
they would get some time to pack up their bags.
Oh, yeah. No, I was just wondering. I know sometimes
Unfortunately, I don't know. I mean, I know that during COVID, there was a lot of provisions, but
I wasn't even thinking of that. I just know I've
Yeah.
had tenants before that stopped
Yeah.
paying rent that were over a certain age, and they said, you can't.
But I assume, Mr. LaPointe, there will be a management company.
Yes.
So there will be a management company, and so they'll be right on top of these things. This isn't a situation where we have somebody that isn't aware of landlord-tenant law. They'll have somebody that's going to be right on top of these things, unfortunately.
Okay.
Andy, if I could too, when we first started, it was something we were hoping to raise money privately and be able to fund this on our own. As we, especially over the last couple of years, we got into a number of different things. To be honest with you, a lot of the private money's dried up. They don't like the 62 and over. It's too much of a limited pool for them. They want renters of all ages. If I could take it back, I probably would have gone family style. I still think it still could be on the table if we had to pull this and come back family style. Not what we want to do, was never our intention. But looking back on it, I should have just gone family style. We would have gone through the whole thing, would have probably taken the same amount of time, would have gotten approved through the state, and we would have another family style rental, 144 units in Abington. So our thought was we consider it protecting the town. We consider it, resources saved, stuff like that. So again, I said at last meeting, we live in this town. We thought it would be a much better fit than just going and getting a 40B family style, similar to what you're going to get, I think, now on Summer Street. This would have been a similar project. That wasn't what we were looking for. But as we got into this, like I said, and I think Amy may have even had a better idea than I did, one of the main funding sources for this is HUD. And, after going over the last couple of years, through different people, sitting with different companies that, frankly, we didn't like, we didn't want to deal with, we didn't want the town to have to deal with, when it kind of all shook out, that HUD financing is the financing really that we need to build this.
It's the only financing they're going to get.
And it's true. And not to mention the fact that, even from the first time we came in, we were looking at a $28 million project. You're now looking at a $42 million project, with things rising. Mm-hmm. So, if this project's going to be built, unfortunately, I would have loved to have done it privately. It's not happening. So this is the only way that this project goes forward, is with that HUD financing. To be honest with you, it's not something we love. If I could have secured financing somewhere else, I would have. It hasn't been from lack of trying, but they have qualifications that we have to meet. I still think far better than a family style. I challenge anyone to disagree with that. I think overall, this is going to be a 62 and over. And I said last time, I don't think anybody's saying, oh, please let me take my kids back after, you've lived on your own, as adults for a long period of time. I don't think anybody's saying, okay, I bring everybody in. I want everybody back under, in my one-bedroom apartment or two-bedroom apartment. So I think this is going to be the exception to the rule. Again, we had the opportunity to just do what Mr. Negrelli said. And frankly, I left a lot of money on the table by not doing that, because that project is a much more lucrative project, much more, especially after sitting down with a number of different people. There'd be buyers for that project, if you look to sell it or anything like that, lining up. But the senior project, it's such a limited space. There aren't a lot of investors in it, which was, again, me being green, I just thought that I'd be able to, entice other people. But to be honest with you, the 62, it's not a big enough pool for people to draw from, and that's turned off a lot of people.
So that was, kind of leads into a question I had. How are you going to market this? Is it going to be as an elderly?
Yeah, I mean, that was always our intention.
Yeah, and that would be in the tenant selection plan.
Well, that's what I was going to, is that something that can be in the tenant
That would be in the
selection?
tenant selection plan, that would be in the
plan as well?
monitoring agreement. This is, well, I mean, the name of it actually is Abington Senior Housing, but, but that would all be in that would be in the monitoring agreement, that would be in the tenant selection plan, that would be in everything. You know, the other thing that, you know, I think that even if Mr. LaPointe had come in with a family development, I think we all would have said, well, why aren't you making this, you know, senior housing, because you're right next to the senior center, and there's a connection, you know. So, you know, even if he came in with that, I think we still would have encouraged him to do the senior housing. Not for any impact to the community, just because the location is actually perfect. But, and then the other thing is, in my experience, the only company that ever does a senior housing and doesn't need any funding is Toll Brothers. So, you know, and they're huge. So if you need funding, then we're stuck with certain requirements that we have to.
Which we were hoping to avoid, but.
Right.
At this
You're not
point-
Toll Brothers.
Yes, at this point now, we're definitely not avoiding it.
So,
Okay, so any other questions from
and
the
Toll
board?
Brothers doesn't do 40Bs. They come in under like inclusionary zoning, which is different.
One
Yeah.
other thing I was curious about is it sounds like there's a state agency that would be required to enforce the tenant selection process. But the town could also enforce things about that. Will the town get like compliance reports and things from whoever is managing the building?
We could get,
It's the only way to enforce it is to know what's going on, I guess, is my point.
so I guess we could require, we can condition that every, could we do quarterly reports of the qualified occupants?
I just want to do, we're
Yearly?
perfectly fine with giving you the reports, but
Yeah.
the same, you know, the same time cycle that we would have to do it with DHCD.
Yeah. So they do. They have to report to DHCD that every single unit has a qualified occupant. They could copy us on those reports, yes.
Yeah.
And I don't know what the timing is on that. Like I said, we
Whatever
don't
it
ever
is,
get
it is. I
involved.
just-
I
Yeah,
think it tends to be annual.
yeah,
Yeah.
yeah.
That I'm almost positive it's annual
Yeah.
because I'm special town council in Westwood, and we get them annually.
So-
One
so-
of our 40B projects.
So the thing is that you have one of these units that becomes free, so they then have to sign a new lease with somebody. So they sign a new lease, they have to make sure that there's a qualified occupant. That qualified occupant has to be over 62. And then they have there's a management company, so it's definitely not going to take them a year to figure out that qualified occupant is no longer there.
Right.
So I think it's unlikely. I think it's unlikely that we're going to have situations where there's a unit that's being occupied and the qualified occupant has died and we don't know about it. Because if we have the condition where they have to be in residence, which I think that's great, then we would be all set too.
That way we can address some of the issues that people have had with, is this really a senior thing or
Right.
is it a
Yeah.
secret, family?
Yeah, so now that we're talking about only 1 and 2 bedroom units, I think that I can't guarantee, but it seems to me that it seems to me that it's probably unlikely that we're going to have a lot of children there.
Right.
But that doesn't mean that,
It won't be some.
people over 62 don't have children.
No,
I mean, that's
right.
not, I don't know.
Bob? Yep.
Could I get a definition of qualified applicant versus lessee, lessor, or are they the same?
The qualified occupant has to be over 62 years old.
Not the lessor or the lessee?
No, they are the qualified
They are the
occupant.
same?
They have the
Yep,
same.
they have to
Okay,
be the lessee.
I just want to make sure I understood the variation of language.
And that's already in the current decision.
Because I could have easily interpreted that differently if I wanted to, based on the verbiage I just heard
Yeah, no.
you two exchange.
Yeah.
So they're both the same.
Yes.
So regardless of what we say, the lessor or the qualified applicant has to be 62 or
Yes.
or it ain't happening.
That's right.
Okay.
And again, the intention is for this to be a senior project.
Right.
So it is, I mean, that's the intention.
So I'm going to open up, any other questions from the board or comments?
No.
So I'll open it up to the general public. Anybody here tonight have any comments on this project, this proposal? If not, I'll bring it back here. What would be our next step?
So, the only thing is that, so we can easily add a condition that states that the qualified occupant has to be in residence. I guess we have to figure out how many months that would be per year. And then the only other thing is that if we can limit it to family of the qualified occupant, which I think is a little bit harder for us to figure out. And so I definitely think that Dan and I can figure that out and bring a complete decision back on the 28th, which is when you next meet, because I'm here on the 28th.
That's fine.
Excuse me.
I told you
I
we
know.
would be done tonight,
That's
I'm
okay.
sorry.
I know, it got
Sorry.
more confusing.
The other condition was that we get an annual report.
Yes, yes.
I just don't want to
Yep.
get that, please. Would that go to the building department?
No, we'll have it come to you guys and the building department.
Okay.
We'll have it, because there's another condition that comes to both of you. I can't remember which one it is, but it's in the original. Oh, it's actually, it actually, let me check, because I think it's already in that. I think we already have that condition.
Okay, I just
In
want
the
to make sure.
original- in the original
We just discussed it, so I
decision.
just want to make sure it was mentioned.
Yeah, so,
Yeah, I don't have all 100 and something.
yeah.
You don't?
No.
I thought you had it memorized. I don't think you need to read it.
So I do have one more question on
decisions
this,
are thorough.
on this tenant selection
Yes.
plan. The condition number 2, the last sentence, says the applicant shall also submit its tenant selection program to the board for its review. It doesn't say review and approval, it just
Let's
says
do approval.
review.
Yeah, for its review and approval.
Okay.
We can do that.
All right, so,
And that would be at a meeting.
Yeah.
That would not be at a public, we wouldn't have to do a new public hearing.
public
so-
notice and all that.
Yeah.
Just- Yeah, okay.
Okay.
All right, so we would continue this, is that what we're looking to do at this point?
Yeah,
Till the April 28th?
that is,
That's our next meeting.
that's the
You
Alta.
guys will be first on the agenda.
Yeah,
We'll give you that.
Well, that's okay.
yeah.
If you do that.
So the 28th, yeah, and then, so what I'll do is I will have, yeah, so that would be it. Those, I don't have, there's nothing else that I was looking for answers on.
So can I have a motion to continue this
The
to
28th.
Motion to continue the hearing from Abington Investments LLC at 1050 Plymouth Street, comprehensive permit dated 11/19/19, on the modification of comprehensive permit to be met at the next date, which is April 28th,
Yes.
2022.
Is there a second?
Second.
All in favor?
Aye.
Opposed? That's unanimous. Okay, thank you.
Thank you.
See you in 2 weeks. All good points.
Contracts with power. People try to get around anything.
So next on the agenda is Derek Correa, 41 Helen Drive. And Cassie, it's my understanding that he's asked that this be withdrawn without prejudice, is that
Yes,
correct?
he has.
Okay. So I think there was an email that went around,
I
and
saw
there's
that.
copies that were left today. So if somebody wants to make a motion to allow this to be withdrawn without prejudice?
Motion to withdraw 41 Helena Drive's petition before the zoning board without prejudice
Is there a second?
until resubmitted.
I'll second that.
Second, any discussion? All in favor?
One point I was wondering about, when I drove by there, we didn't provide like an elevation of the
I
building.
noticed that on the,
And if they come back, it'd be nice to have an elevation of the
Yeah.
building.
Okay.
It's not really something we have to vote on, just
Yeah,
advice.
I'll mention it
just
to him.
yeah. Okay, all in favor?
Aye.
Opposed? It's unanimous. Next on the agenda, Alcova 3 LLC, 268 Washington Street. I'm just going to read the notice. Zoning Board of Appeals, public hearing notice, the Town of Abington Zoning Board of Appeals will hold a public hearing on Thursday, April 14th, 2022, at 7:20 PM at the Abington Town Offices, 500 Glenwood's Way, Abington, on the petition of Alcova 3 LLC, 268 Washington Street, for a special permit under Section 175-21-E-3 for outdoor dining. The property is located on Assessors Map 16, Lot 1 and 2, in the General Commercial Zone. Andrew Burbine, Chairman, Zoning Board of Appeals. Mr. Whitney, how are you?
Yes, very well, Mr. Chairman. Thank you. Many of you know me. I see some new faces. My name is Ronald Whitney. I am here tonight. It's a pleasure to represent John and Kristen Martin. They are the owners of Alcova 3. That is the corporation that they have to run the meat or Gaza restaurant here in the town of Abington. I'm sure you're all well acquainted. It's been in business for over 14 years now. They run a very successful operation. You may ask why we're here tonight, and candidly, we ask the same question. But respectfully, we're here because we were asked to be here. And so what's transpired is that John and Kristen purchased the property back in 2008, and as I say, have run a successful operation, a successful restaurant. And since 2008, they have had an outdoor seating component to their restaurant. And that was by way of a variance that was granted to the prior owners, common to Justo and his family. And so I have a copy of that variance here. And in the variance, it specifically allows outdoor dining. And I have drawings of what was proposed back in 2006 when the Justo family came before your board and was approved for outdoor dining. And so when John and Kristen purchased the restaurant in 2008, they basically took up the same footprint and began to serve food inside and outside, which they've done ever since. Now, what's changed, if anything, is that in 2020, as we know, we had a pandemic, and the governor issued rules about outdoor dining somewhere along the way over the past 36 months. And so John and Kristen were able to take advantage of those new rules, which we all understood was somewhat temporary, and they were able to expand what they had for dining from 30 seats to 50 seats. That's what they have currently. That's what they operate with. 50 seats outside, and I think it's somewhere around 98 inside. So there was talk earlier this year about the governor relaxing or perhaps terminating those outdoor dining rules. And so John and Kristen received a letter from the executive secretary here in town stating that they had to come before your board to get a special permit in order to continue their outdoor dining. Personally, I would disagree with that conclusion, but rather than fighting City Hall, we figured that we would file for a special permit. They do have a variance, and I'd be happy to show it to the board.
We actually have
The
copies of
variance
it.
right here.
We have copies of it.
We got copies of it.
Yeah,
Yeah.
okay, yeah. So they do have a variance, and they will, according to the letter and according to what our plan is, will be required to go to the planning board. But I can tell the board that the outdoor dining configuration that you were to see today, if you went down to the restaurant, is the same footprint, I should say, that's been there since 2008. And
So no expansions on it or anything, it's the same thing?
No, it's just the way it's been for years and years. And it's operated successfully as far as John and Kristen are concerned. They are pleased with the way it operates. Their customers are pleased with the way it operates. And so we come here tonight, as Mr. Chairman, you aptly read, seeking a special permit under 175-21E3, but knowledgeable of the fact that the variance exists out there, which gives them the rights to outdoor dining, separate and aside from the special permit. I'm told that the letter that John and Kristen received went out to all restaurants in town who were seeking to carry on their outdoor dining component to their operation. So, not sure if anybody else has come before your board, but John and Kristen have always wanted to do the right thing, and hence they come before you tonight.
Any questions?
Well, I see a variance here, and it was approved. It just seems like the state law has changed for making everybody, what was I just looking at it, they have to apply for it every year? Is that correct?
For what? Rich?
Right here, that they have to apply for it every year? Even though it's a variance and they've had it for forever?
I don't know.
So if I may, Mr. Chair, the variance is for, what did you say, 30 seats?
Yeah, 30.
So the variance was for 30 seats, and they now have 50, correct?
I stand corrected. The variance is for
Outdoor dining, it
Oh,
doesn't,
no
it doesn't
seating.
limit,
No
it doesn't
seating.
limit the number of seats.
Oh, yeah, I don't see anything on
It
it.
doesn't limit the
Okay,
number.
so the governor's order back in 2020, which was extended to 2021, which has been extended to April of 2023, allows cities and towns to relax outdoor dining with regard to the ABCC, which is the Alcoholic Beverage Control Commission. So it also allows the select board to relax any zoning if they want to. So what appears happened is that in Abington, the select board, I think, has agreed with the relaxing of the ABCC, but would like the zoning to be approved by the zoning boards, meaning the planning board and the zoning board of appeals. So if you have already issued a variance with no seating, I guess I would
Correct it?
I would issue a new variance to allow them.
Well, they're looking for a special permit now.
No, they're looking for a special permit.
You're looking for a special permit?
That was the application,
Yeah.
because that's what we were asked to do.
Did you want to see this?
So,
Sorry, I don't know anything about this. I'm
Yeah,
sorry.
yeah.
I was here for something else.
Yeah,
They do
for
this to
sure.
me all the time.
Or you keep sitting there, so...
I know,
If you got any like time, we would have
I-
discussions about
I
this.
try and leave and you guys yell at me.
No, we won't yell at you.
So,
Here it is, right here.
okay.
Right.
So I think that what I would do is I would issue them, yes.
Amy, it's because 175 to 21, it changed, so it
Yeah.
went from,
It
yeah, it went
changed
from a
from
variance.
Section
to a
E2
special
to
permit.
E3.
Oh, okay, so great. So you only need a special permit,
Yeah,
which is
if-
much better
if-
than a variance.
If the
Okay.
board would be so kind
Yeah.
as to grant the special permit, we'll just carry on with the operation as it's been constructed. Now, I think I made it clear, but just like, in the interest of being very transparent. So before COVID, there were 30 seats. And with the COVID relaxation, there are 50 seats.
Right.
So there are 50 seats still operating within the same footprint. Okay.
So did the total number of seats in the restaurant go up?
No.
So you just took seats from inside, put them outside?
As far as the inside has always been 98.
Oh, okay, so you still have 98, and then
Yes.
you had 30, but now you have
Yeah.
50. So you have 20 extra seats outside,
Right.
essentially.
And 98 being if everybody had 4 at every floor.
Oh, yeah, right,
You know,
yeah,
yeah.
every seat
Yeah.
was possibly full.
Okay.
But they weren't limited in the variance as to how
I
many
know.
seats they could
Right.
have
I know,
outdoors.
so,
Oh, weird, I mean,
So what you're looking for is a special permit now for 50 seats outside.
Yes, yes.
or do you do just the footprint?
Because otherwise you're going to be limited to 50 seats. If you want to go over that, then...
Right, I think perhaps the best way
you get any more than 50 out
the
there?
best way
Yeah,
to
yeah,
address it,
absolutely. I mean,
So footprint
So
would be the right
footprint?
thing to do.
So do
I think
footprint,
the
do
best
that.
way to address it would be a special permit to allow outdoor dining.
In that
In
footprint?
In this footprint,
In that footprint, if you wish, yeah.
No, it doesn't
And then-
change anything that they have to go in front of some other
So,
board.
no. So they would have to, so eventually, I'm sure you know as restaurant owners, eventually the governor's order is going to expire.
Yes.
So if they wanted to increase their number of seats, they'd then have to go through the whole licensing,
Site plan.
ABCC and all that stuff.
Which
So-
is in process.
Yeah.
Yeah.
So
We
right
don't want
now,
to wait.
right now, you guys can approve the footprint, and then the number of seats outside,
It's gonna be
they have
left
to worry
to them
about with other.
other entities,
with
right?
select, with the select board and the planning board.
We
and
are
stuff.
going to the selectmen and the planning board on site plan review.
So that's
You have-
the
I would do
best way to
that.
do it,
I
right?
would do that, and then they don't have to come back before you guys. And you guys, as long as you guys are okay with that footprint,
Yeah.
which.
Which has been there
It's been there forever.
forever, yeah.
Is the other, one other thing I was wondering about is that I haven't noticed any like parking issues there either. The parking lot looks full on busy nights, but it's not overflowing onto the street that I.
You have other parking, right?
So we have all our employees park, I rent the block behind the Route 18 Superstore.
Right.
All our employees are back
I
there.
see them walking all the time.
Yeah, so they're on the same side of the road, you don't want to
Yeah,
walk.
so like-
over.
Right, exactly.
Middle of the street.
Yeah.
No, it's great.
No, they're on the sidewalk.
It really works out great.
Yeah, it does, so it's, it's all for guest parking.
And we just review parking, as per your regulations, there are 75 spaces, and that's just what's required by your regulations.
Right,
And
okay.
you-
I guess I'm trying to plan it even with the 50 seats outside there. I haven't ever observed any like mess of parking.
And again, that will be
Very well
addressed by site plan with the planning board.
planning board.
Yeah, they will, and actually, and even the licensing, even the select board will look at number of tables, number of parking, all
Well,
that
they've been
stuff.
good for the town. They've
Yeah.
been in business for a while, and
Yeah.
Yeah.
No issues.
Okay. Any other questions on the board? If not, I'm going to open it up to the general public. Yes, sir? Just please take the microphone and your name and address, please. Thanks.
My name's Ed Robichaud, and I own I believe, the closest abutting property at 254 Washington Street in Abington. Excuse me. And I'm very happy the Mia Ragazza is quite successful. And just so I understand, this is not to increase the outdoor dining, just continue with what's there now?
Correct.
Well, the only issue I have, and it's a minor one, they're so successful that their parking lot has been completely filled on several occasions, and their customers have parked across the street in my parking lot, which, it's going to inhibit my tenants' use of the property. So I guess I don't have an objection if it's not increasing the outdoor dining capacity, but I am a little concerned about the parking because even before this hearing, it's been an issue. In fact, so much so that I'm going to have to engage a tow company and implement trespass towing, so that if there are anybody parked in my property that's not entitled to be there, their cars will be towed. But it's kind of upsetting to me. I was there one time, and I was on the phone, and I turned around, and somebody pulled up and parked right next to me and walked across the street. So I said, what are you doing? Oh, we're going in the restaurant. Well, you can't park on my property. This is private property. So I'm glad that they're successful, and I wish them continued success. But we have to be good neighbors, and my property is my property, your property is your property. And,
Okay.
that's the only thing I have to say. But I guess if it's continuing what's existing now, I really don't have a complaint.
That's what's here before us tonight, is to just continue the
Okay. That's-
outdoor dining, yes.
Yeah, that's fine.
thank you.
Thank you. Thank you for your comments.
So one, I do have another board that's actually run into this kind of problem with a restaurant. So perhaps when you walk into your restaurant, you could maybe have a sign that says, please respect our neighbors and don't park in our neighbors' parking lot. And as far as I know, that has helped in the other community that we represent.
that sign that sign is fake.
Oh, you already have it? Okay.
Well, if you start towing vehicles,
I tried.
if you start towing vehicles, they're not gonna,
I didn't realize there were still any issues about, I think it's been about 8 years, we took the house down on 276 to make it parking, which obviously made it a lot, a lot more available for people.
Thank you. All right, so I'm going to bring it back to the board. Can we have a motion to close the hearing?
Excuse me, Mike.
Oh, I'm sorry, I didn't see you out there.
So my name is Bernard Brannigan. I too am a business abutter, and I own a property across the street at 265 Washington Street. And the issue remains parking in the neighborhood, and again, I'm not here to hold the Martins back from their success in business. Never have been, but circumstances have presented themselves to be somewhat dire in some circumstances relative to people trying to cross Route 18 when there is not available parking there. You're mentioning the fact that through COVID, they acquired an additional 20 seats exterior on what was a variance given years ago to Carmen. Okay? Part of that variance was developed as an interior development, as I understand, and part of it now remains exterior. So we've taken 30 seats and made them 50 based on COVID. And that response, respectfully, probably was put in place because people didn't want to sit inside during the pandemic. Being a physician, I understand that circumstance being the case. Now, I'm not sure if your board has the right and authority to look at the circumstance regarding seating and parking, but this is an issue within the community. Again, I'm trying very hard not to be someone who's going to obstruct their capacity to remain successful. That's not what it's about. But a sign hasn't worked. The circumstances have presented to be significant enough that myself have had to tow vehicles. I've had to put a chain up across the parking lot.
right, I've seen that.
Okay, in order to try to control that. And in some cases have had altercation in my own parking lot relative to it. Now, that's not Martin's fault. They don't have control over who walks across the street. And obviously, a person who would make that choice isn't making appropriate choices to start with, okay? That being said, though, if we're adding, or if have an additional 20 seats have been added to try to accommodate the public's perception that they did not want to sit inside and that we were going to give the restaurants this opportunity. And now, as we come through the end of the pandemic, we are looking at this again. We have to start to recognize that those interior seats now are going to start to be used. And subsequent to it, we now have gone from 98 seats interior to what was 30 to now 50 at 148. I was in location before the Martins purchased their property. I can assure you that Carmen did not have seating in his original site for 98 interior. There has been additions on. And again, they have made an effort to resolve to some level the parking issue. So I'm not here to throw them against the wall, except for the fact that there comes a point, especially with exterior work, where I know I can only sit 12 people at my dining room table, but if I have a party out on the patio, I could have 30, and some of them may never sit. So all of a sudden we go from one scenario to another. Now, I'm not sure if I'm talking to the right people relative to this circumstance, but the reality of the circumstance is that it is not the quality of their product, not the quality of the people, but it's the circumstance around the parking. It has been a persistent issue in a neighborhood for years, and it has to be looked at to some level. So,
Thank you. So I think, again, our role tonight is just to look at a special permit for outdoor dining, which is happening now. As far as those issues with seating and that's going to be in front of the selectmen or the planning board when they do this, in parking and those sorts of things. That's where those would be answered. Okay?
Do we get notification on that?
Yeah.
Yes, you will.
We should.
Yep. Well, I'm not sure about the select.
I don't know about the licensing, but you will on the site.
You will on the site plan with the planning board, yes.
Yeah.
Mr. Whitney, do you have?
Just very
Yep.
briefly, Mr. Chairman and members of the board, the Martins provide 75 on-site parking spaces. They provide 15 off-site, total 90 spaces. The zoning regulations here in general commercial for a restaurant operation is one space for every 2 seats. That figures out to 75. They provided 90. And both gentlemen spoke well, very eloquent, and understand their difficulty. Understand, too, that the Martins don't have control necessarily over people that just decide to park here, there, or everywhere.
Understood.
Yeah.
Yep. Thank you. So anything else from the general public? If not, I'll bring it back to the board. And you could have a motion to close the hearing?
Motion to close the hearing?
That's got to be made by one of us. Bob.
Okay. I'll do whatever I can.
I need to close the hearing on this.
Do we have a second?
I'll second that.
All those in favor? Aye. Opposed? Now we have to take a vote on the petition to grant a special permit. Do we have a motion?
All right, I'll make a motion to accept the petition of Alcove 3 LLC, 268 Washington Street for a special permit under 175-21-E-3 for outdoor dining. The property is located on Assessors Map 16, Lot 1 and 2, and in the general commercial zone.
Is there a second?
Second.
There's a motion and a second. Any discussion? If not, all those in favor? Aye. Opposed? That's unanimous. Thank you.
Thank you for coming.
Thank you all.
Thank you.
Good luck.
7:25, we have Scott Tomlin, 60 Jennings Drive.
Exit stage right.
This is just an in-law.
Just in,
No, we need you.
So Mr. Tomlin is looking to rescind his in-law status to his property located at 60 Jennings Drive, effective immediately.
Is he here?
He is not here.
What does that mean?
Yeah, what does that mean?
Well, if you look at, in your package there, he sent an email to Marion. His mother-in-law passed away a few years ago, and the in-law has been sitting empty since. As you stated, when we sell a house, the new owners would have to apply for the special permit anyway, so there is no benefit for us to keep the status. So they get that annual affidavit that they have to sign saying that somebody living there. There is nobody living there at this point in time, so he wants us to rescind the special permit, which...
Does the fact that they have a second bathroom and a second kitchen and a second bedroom or a third bedroom or a fifth bedroom,
I think they have to remove the stove.
does anything have to be done to the property to secure it that it wouldn't be considered to be a in-law suite?
I would say so. Call me crazy, but...
Call me crazy. That's exactly what my word.
So the definition...
It would go away if they didn't reapply though, right?
No, not get involved.
So,
The definition...
just to Dave's point, if they don't send that affidavit back, it gets rescinded
Just gets
anyway.
what's in the next
Yes,
year anyway, so.
yes, so the definition of dwelling unit is
I'm sorry.
one or more living or sleeping rooms arranged for the use of one or more individuals living as a single housekeeping unit with a permanent provisions for cooking, living, sanitary, eating, and sleeping facilities. So, if you rescind the in-law status, what zoning district is it in? Do we know?
That's my neighborhood.
It's 20?
It's not
I think it's R30.
R30 does not allow a two-family. So you would then, by rescinding that, the building department would have to seek enforcement to have the kitchen removed,
The kitchen?
the stove.
Still.
Yep.
So would that automatically happen if they didn't reapply for the permit?
It could, although it would be,
Yeah, no.
in that instance, it would be an enforcement issue.
Only if your neighbor
And
complains.
so I guess
No, I'm just...
to make my life easier, which I know you're all here to do that.
Of course.
It would be better if you rescinded it, because then when we go for enforcement, We have the fact that they asked to have it rescinded, you rescinded it, and therefore they now have to take that out.
this over.
Rather than them not reapplying, then we have to chase them, you know what I mean?
But they have to be present for a vote, right?
No.
Really?
Did they ask to continue?
No?
No,
They're not here.
they're not here. I mean, you can continue it to the 28th, but that, I mean, you're doing what they asked.
Right.
Should we be voting on something when there's nobody here to
They
represent?
asked for it to happen.
Yeah, they asked, and
You're
it's
not
not,
denying
yeah,
them.
it's not a public
That's
hearing
right,
either,
that's
so
true,
it was just
that's
a,
true.
yeah,
Yeah, and you're not denying them, you're actually doing what they've requested.
yeah.
Do they realize what they requested?
I don't know.
Too late now, isn't it, huh?
Very good question, Mr.
I
Pierce.
agree, Rich. But that's what they've requested, so, and they're not here to discuss it, so.
I got the impression from the fellow's email that our city property, or town property taxes are related to having a functional in-law apartment.
Yeah, I'm sure.
And that's why he wants to have it.
I'm sure. So the one thing that we cannot ever rely on from the zoning context is assessor's records. So if an assessor determines that it's a two-family, that doesn't mean that by zoning, it's a legal two-family.
Right, yeah, you
So-
know that, yeah. We went through that before.
Yeah, so I think
So it's up
that's,
to the homeowner to argue that point for assessment purposes.
Yes.
Not us.
they need to seek an abatement.
Yeah. But maybe this is why he's doing this, is so he can.
Probably, yeah.
Like the,
But
The three,
yeah,
three
does that, I
it's the
haven't-
normal.
what's the
Patsy got
pleasure
all
of the
stuff
board?
today, thank you.
I'll make a motion to accept,
To rescind
we
the,
rescind the special permit that was granted on May 26, 2010.
okay, is there a second?
Second.
You can second, but I can't recognize it, so. So Rich second.
I second.
No, that was
The other
Rich.
Rich, okay.
Yeah, the other Rich. All those in favor? Aye. Opposed? That's unanimous. Okay, so we need a motion to adjourn.
Shutting up.
I move that we adjourn.
Bob, you can second this one.
I'll second this one.
All right.
All in favor? Aye.
This is why you're my favorite board, 8:20.